Hello friends, in the series on the income tax cases, today we will discuss the case of Telangana State Chapter Indian Radiological and Imaging Association versus Income Tax Officer Exemptions. This case has been reported in 105 ITAT Tribunal, short notes 13, and the matter has been decided by Hyderabad ITAT B bench, and the date of the judgment is 15th June 2023. Friends, this case is very important in this respect that nowadays, whenever any income tax form is filed on the income tax portal, whether it is related to the income tax return, whether it is related to filing the tax audit report or any audit report, or filing any registration form like section 12A ATG, then it is the duty of the assessee or the professional to take utmost care in filing those forms. If any mistake happens, then due to that mistake, the assessee has to face the music of litigation in the long run. And this litigation can go to such an extent that even this litigation can result into the existence of that organization. In this case, the assessee applied for provisional registration under section ATG by filing the form 10A. When the assessee filed this form, the assessee has to choose the section code 12, but by mistake the assessee choose the section code 11. But at the time of granting the provisional registration, as all we know, it is an automatic registration. The Commissioner of Income Tax Exemption didn't point out this mistake on the part of the assessee and didn't get it rectified from the assessee, but the provisional registration was granted. The assessee commenced its activities, and after the commencement of the activities, the assessee applied for renewal in form 10AB. But when the final registration is given, then as all we know, all the documents of the assessee are scrutinized, and when the Commissioner of Income Tax Exemption was dealing with this application of renewal under section 10AB in form 10AB, then he came to know that the assessee has chosen the wrong section code at the time of the provisional registration, and he noticed that in place of section code 12, the section code 11 was chosen, and the Commissioner of Income Tax Exemptions denied the renewal of the exemption on this ground only. The assessee has no option to move to the ITAT in an appeal, because when the Commissioner of Income Tax Exemptions rejects any application, then the next step is go to the ITAT and not the CIT appeal. When this matter was before the ITAT at the first end said that the Commissioner of Income Tax Exemption has made a mistake in rejecting the application for renewal just on the ground that at the time of the provisional registration the section code was selected wrong. The Commissioner of Income Tax Exemption made a mistake in rejecting the application of the assessee for renewal. The ITAT said that the assessee was at a mistake, there is no doubt, but at the same time the Commissioner of Income Tax Exemption was also at a mistake. The best recourse which was available to the CIT exemption was that he must have issued the notice to the assessee at the time of the provisional registration, and get this mistake rectified at that time itself. So the ITAT directed the Commissioner of Income Tax Exemptions to reconsider the application of the assessee and grant the assessee the final registration on the basis of the application made by the assessee in form 10AB. Friends, the significance of this case is not that the ITAT has given relief to the assessee, but the significance of this case is to make us understand that the filing of the forms are very important. Even a single mistake can bring the association into a situation that it has to face a lot of harassment on the part of the department, because the litigation is not costly only in respect of money terms. It is costly in terms of the time involved and the effort involved to get our matter rectified at the appellate stages. At the end of this video, once again I am repeating the name of the case. The name of the case is Telangana State Chapter Indian Radiological and Imaging Association versus Income Tax Officer Exemptions, and this case has been reported in 105 ITR Tribunal Short Notes 13, and the matter has been reported by Hyderabad ITAT B bench, and the date of the judgment is 15th June 2023.